second day of the ICDR Americas Conference. It's a pleasure to be with you. We had a great day yesterday with our Tertulia sessions and our corporate council discussion. We're looking forward to today's discussion of a Tertulia report and really kind of some of the thoughts and outcome and feedback that we had from the Tertulia sessions. And then we'll also have a great rapid fire discussion and current developments moderated by my colleague Luis Martinez, who's been fundamental and very supportive and also organizing this event. I just want to do a couple administrative reminders here to start off with. There will be CLE code words throughout today as well. Let me just go over and provide the default language that we receive for CLE. West Legal Ed Center is procuring continuing legal education CLE credits on behalf of the American Arbitration Association. This program is available for CLE credits in California, Illinois, New York, and Texas. If you are licensed in a different jurisdiction, you will be able to request a general certificate that you may be able to submit in for your own credit. We recommend that you verify that your jurisdiction allows submission by attorneys for this type of course. Approximately a week following this program, you will receive an email with instructions to request a CLE certificate from the AAA Education Services. This is important. Make sure you look in sometimes your spam folder or otherwise for that email. That's really, really important. So today, again, we'll be giving the CLE code words. If you'd like to receive that, you'll need to make sure you keep track of those code words and note those down. You received a form before yesterday's program where you can kind of keep track of all those 17 words. You will be required to give those as you apply for the CLE, and we won't be able to give those after the program. So that's the CLE. Now, while we're in a plenary session, both all of today, we would ask that people turn off their cameras, and you're muted, I believe, if you'll keep muted, and we'll just have our faculty really keep their cameras on and unmuted so that discussion will be easy for all of us to see. Thank you all. I want to give a special thanks to our ICDR Rules Committee. Not all of them are here today, but they've done a tremendous effort in helping us update our rules. We started about a year ago at this time with this endeavor, and Ryan Robertson is the chair of our committee for this, and we've included 3 members, Lucía, John, and Alan. I'll let Ann introduce them a little bit more, and Eric Tuchmann's on this panel as well. So Ann, I turn the time to you and look forward to this session. Thank you.
Thank you very much. Yes, as Steve said, this has been a year-long project, and we have here with us today Alan Crain, John Townsend, and Lucía Ojeda. John and Alan are both from the US. Alan was a former general counsel and is now an independent arbitrator. John is with a very large DC firm and sits as an arbitrator, and Lucía acts as arbitrator and mediator in Mexico, and we were very pleased to have them. It was a very international group. In addition to these 3 individuals, we had an individual from Poland, one from England, one from Germany, and one from China. So we had a cross-section of the civil law and the common law. It was indeed a year-long process. I'd like to give you a very short background on the ICDR International Arbitration Rules. They were first introduced in 1991, and they were modeled on the UNCITRAL arbitration rules. And then in 1998, the ICDR was created. And then in 2006, the ICDR added the groundbreaking provision on emergency relief before the formation of the tribunal, which of course we all refer to as the emergency arbitrator. And then in 2014, there were additional changes. And of course, there was the change to address consolidation. And we are the only ones who have a consolidation arbitrator, as well as joinder and various concepts relating to e-disclosure. This committee, standing on the shoulders of those who have gone before us, were tasked with reviewing, updating, and in some instances, innovating once again in creation of what will be the new rules that will be introduced in 2021. In that regard, we'd like to discuss some of the rule changes or proposed rule changes with you. Yesterday, for those of you who did not join us, we had about 170 people join us to discuss the new rules, breaking down into groups and giving their thoughts. Our goal here in the next 55 minutes is to talk about the rules, some of the philosophy underlying the rule changes, and also discussing some of the comments that were made yesterday relating to the rules. So with that background, one of the very hot topics from yesterday happened to be the issue of third-party funding, which, as everyone knows, has become a very hot issue in the arbitration community itself. And there is a new Article 14 that indeed addresses third-party funding. And John, would you like to discuss that for us, please?
And I'm sorry, I need to give a CLE word here. The first CLE word is summary. I should have started off with that. So the first one is summary in the CLE word.
Thank you for that. John?
Yeah, Steve just summed it up. There's, for those of you who studied the rules carefully, the new rule is 14.7. It's a subpart of 14. And as Ed observed, third-party funding has become a sort of hot button issue, you know, in a lot of different kinds of arbitration. I think probably most notably in treaty cases. But as far as I know, the ICDR has never handled a treaty case. So we don't have to deal with that one. The difficulty of putting it into the rules is to make some provision that makes people comfortable that any conflict that might be caused by the presence of a third-party funder will be brought out into the open without, you know, complicating everyone's life with relations with insurance companies, parent companies, others who have either committed funds to pay for a proceeding or who have a financial interest in them. And while there was some comment yesterday suggesting that, oh, disclosure should be mandatory, not optional, what the new rule actually provides is mandatory disclosure, but at the option or election of the arbitrators. So what it provides is that the arbitrators may, in any case, require disclosure of any other entity or person that is contributing to the funding of a case or that has a financial interest in the outcome of a case. But that disclosure only becomes mandatory if the arbitrators say, we want to know. Now, of course, any party is free to tell the arbitrators, you know, please ask, in this case, you need to know, so that there's always the possibility of a prompt from a party to an arbitrator saying, please pull this trigger. But the committee felt it was sufficient that the arbitrators have the tool in the box and be able to say, please put this on the table, we'd like to know it, without requiring that in every case, parties put out information which is, as I said, would pull in insurance companies' parents and possible other relationships that really would not be particularly interesting or necessary. So that's the way we tried to thread this needle. I think it is sufficiently addressed so that anyone with a concern can raise it to an arbitrator and the arbitrators can have the information put out there. And of course, the relevance of this is primarily conflicts, and to make sure that an arbitrator isn't surprised halfway through a proceeding to find that it's being paid for by someone near and dear to him. But that's what we tried to achieve, and I think we did it, in a reasonable way. And back to you.
Okay, thanks, John. The next topic that we wanted to explore, which was also a very hot topic yesterday, was early disposition. And Alan brings a unique perspective to this particular rule revision because he was a general counsel at one point in time. So he was always very anxious to have his cases completed quickly and expeditiously. And now as an independent arbitrator, he is confronting this problem. And so Alan, as you and John were the two main drivers behind this particular rule, perhaps you could explain the thought process.
All right, well, thank you, Ann. As you said, John and I identified at our first meeting of the Rules Committee that this is an issue. How can we be supportive of the opportunities that are presented by arbitration to move things along quickly if we don't have a clear rule on the opportunity for early disposition? And of course, there's great sensitivity. I've sat as an arbitrator for over 30 years. And as Ann mentioned off and on, I've also been general counsel of 3 different multinationals. But from both sides, both of those roles, I've always been interested in having the arbitration move forward efficiently and as effectively as you can get it to be, as quickly as you can. So the rule takes that balance into account. We did a lot of research in regard to what other rules do and also what parties are concerned about, particularly as an arbitrator, enforceability. And that's why the rule has 3 parts. First, you have to basically apply, the parties have to apply to the tribunal to get leave to go ahead and file for a request to submit an application for disposition. And you have to meet 3 requirements: that there has to be a reasonable possibility, and that's all, of succeeding, that it will dispose of or narrow 1 or more issues in the case, and that consideration of the application is likely to be more efficient or economical. And of course, the last one's for the tribunal to decide. All of them are, obviously, in allowing it. And then importantly, we made clear that each party shall have the right to be heard and a fair opportunity to present its case regarding whether or not the application should be heard, so that ensure both parties have a full opportunity so that they can't argue later they didn't and the award should be overturned. And then the last portion is the power of the tribunal to issue awards or orders in accordance with that. So as I said, this took a lot of study to balance it right. And we don't want to encourage a lot of US style motion practice trying to get things heard and tie up the proceeding with it. So we trust that tribunals will be sensitive and be very rigorous in deciding whether or not they should allow an application for a dispositive motion. I think it is important to note that I think it's the Third Circuit late last year on the AAA has 4 sets of rules, or ICDR rules. Their employment rules, construction rules, and commercial rules. And in the context of one of those other sets of rules, a federal appeals court found that the process that was provided for there was enforceable and the party's attack on the award was not going to be heard by the courts. So in summary, that's where we are. And I think it'll be a great addition to the rules.
I will say that this one did engender quite a bit of comment within the committee itself because of the civil law lawyers and the common law lawyers that were on the committee. And because of that, I think we have hit the right balance on how to draft a rule that will allow this to occur. One of the bywords in the last few years in arbitration has related to the question of transparency. And there has been some confusion among the users regarding the Administrative Review Council. And Lucía has volunteered to explain to those of us who weren't familiar with it exactly what the Administrative Review Council is.
Thank you very much. First of all, thank you very much for the opportunity to discuss these important proposed changes. As you know, the ICDR in 2019 implemented the new practice of having the International Administrative Review Council. And it of course handles some administrative decisions like challenges of the tribunals and other issues that prior the constitution of the tribunal. So the committee felt that it was important to have a new rule, to introduce a new rule. It's new rule 5, in which it makes transparent the existence and how this administrative review council works. In the discussions yesterday, I think that the reaction to this rule was positive. The discretionary aspects of the new rule was viewed favorably. What it's important is that the experience of the participants with the operation of the councils were positive, and that's encouraging. And particularly highlight that the short time it looked for the decision to be rendered and informed to the parties. So I think that the council is working well, and that's good to know. And it was recognized that having a compact council of just 3 voting members and weekly meetings brings more efficient and expediency in the operation of the same. So that in cooperation with other similar bodies that are in other institutions, and that's good. However, there were some comments about certain, not concerns, but suggestions in order to have a a body of more composed seasoned arbitrators or practitioners to include it in this council in order to have more brain power in this council. And but I think that it was very welcome, this provision. And the other issue that was discussed is the non-recent feature of the decision making of the council was discussed. But of course, we have to think about this balance between efficiency and, of course, recent opinions. So I don't know if someone wants to add anything.
Thank you, Lucia. Now it's time for the next CLE word, and it is advisory. Advisory. When we first started this particular task of doing the rule revision, we had not yet entered into the pandemic. And of course, the pandemic has changed the lives of everyone. And this conference is a beautiful example since we're doing it by video conferencing. And so there are a number of rule changes and additions that have been put into the proposed 2021 rules to address this new world that we are in at the moment. And they're sprinkled throughout the rules. And Alan has volunteered to discuss those for us.
Well, thank you, Ann. As you said, the pandemic wasn't quite on us, but from the start, we were looking for things that could make the ICDR rules more sustainable and more ready for the future, or the future's already here, and what can we do with what we have? And the pandemic made it clear we needed to address a number of things quickly. So in conduct of the proceedings, which is the Article 22 of the rules, we've added changes to 22.2 and 22.3. In particular, 22.2 lists out the different ways how technology can be employed and asks the party and the tribunals to specifically consider that at the preliminary hearing, and includes video, audio, or other electronic means that can be used to increase the efficiency and economy of the proceedings. And the next section says at the preliminary conference, the tribunals should consider with the parties what rules and procedures for data protection and security apply to the proceedings. So the cybersecurity, which is a big issue and will only continue to be a bigger issue, and obviously during the pandemic, using techniques such as the Zoom call we're on right now, there are different levels of security that can apply and how you go about it. So it's something that needs to be, in our belief, something that needs to be addressed at the preliminary proceeding. So that's now in the rules of preliminary hearing. The other thing was electronic signatures. Now, some countries still don't allow electronic signatures, but where they do, we've made clear in the new Article 32, formerly Article 29, that electronic signatures are allowable. So again, these things are helpful now in the pandemic, but we think they're going to be helpful for speed and efficiency going forward as well.
Okay, thank you. And also something else that's been new on the horizon in the last year has been the Singapore Convention, which of course relates to the ability to enforce mediation settlements worldwide. While there are not that many signatories to that particular convention at this moment, it is anticipated that it will begin to gain ground. And in view of not only the Singapore Convention, but the AAA and ICDR's commitment to mediation, there is not only an article within the arbitration rules themselves, but also in the mediation rules, greater procedures relating to mediation. And Lucía was very instrumental in helping to design those particular rules. And so we've asked that she please report on that for you.
Thank you very much. Of course, mediation is a very important trend, and it's something that it's growing in the world. Of course, there are many countries in which mediation is not well known, but of course, these rules will help to educate the community in the using of the mediation and could give them more clarity of how it works. So in the new draft rules, we have two features. One is changes to the international mediation rules, and in order to make more clear the participation of the parties, and they are encouraged to participate actively in the mediation proceedings, and they have some role, of course, in nominating the mediator of its preference, and that's something that it's important introduced in the new Rule 9. And what it's also important is this feature with respect to the Singapore Convention. Of course, as Anne said, there are many countries that are not already signed or ratified the convention, but of course the US has done it, and there is another. There are a growing number of countries doing that, and of course it was important to take into account what the Singapore Convention says. And it was, according to the convention, it is required that for the enforcement purposes, that the mediator signs the mediation document. So there were general comments on this, and of course it was a positive effects of the changes. Of course, there were comments regarding the fact that more education on mediation is necessary and perhaps requires development of more soft law in order to promote it. That also participants know that there are cross-cultural challenges and soft skills that are relevant to the reaction of mediation, but in any way, these are an improvement. There was a concern regarding the possibility of the mediator to execute the settlement agreement. And in this regard, it was mentioned that it does not pose any problem if there was a disclaimer in the sense that mediator was not substantially responsible or liable for the content of the mediation. And there were other concerns that of course, it's something that shows the need to more discussion and education on these. For example, there are people that express concern about the written recommendation of if this statement is discoverable, it is accurate, that can parties opt out on the joint recommendation. Some felt that the mediator's statement is, if disagreed with, will reduce the likelihood of a settlement. But of course, I mean, I think that there is many things to discuss on the mediation, but I think that everybody thinks that was a good addition. The other part that it's important is that in the rules, in the arbitration rules, there is the introduction of a new Article 6, that it was former Article 5. And what this do is that presumptively put the mediation to mediate the dispute, but any party can opt out. What is the background of this rule? Well, it is important to note that the most version of the commercial rules incorporated this presumption. And it seems that formally this was discussed in the previous round of changes of the law, but the international community was not ready at that time for this type of rules. But currently, it's important to understand that most parties opt out, but the rule is an important statement about the usefulness of mediation and invites the parties to strongly think about the use of the mediation. So I think it's part of the education process, and it's important for the rules. And there were some questions about the mediation and the arbitration going in the same track. But I think that everybody feels that if this will reduce or permit that the arbitration is not hinder or because the mediation, it will be a good feature. Other concerns were important, but it's important to the people know that they could opt out, and there were a lot of questions on when they can opt out. They can opt out at any time, and this is something that I think that it's because, of course, the rules about mediation has not been widely known, but of course, everybody thinks that this will be a good feature for the new rules.
Thank you, Lucia. And I might add to that, that in Article 2, which is the notice of arbitration, and in Article 3, which is the answer and counterclaim, the new rules will also require the parties to state whether or not they are willing to mediate the dispute prior to or concurrently with the arbitration. And a definitive statement needs to be made as a corollary to that. I'd like to move on to what we generally call jurisdiction. John Townsend is a member of the ALI subcommittee that addressed the restatement of arbitration, and the issue of jurisdiction and gateway issues in particular has been somewhat of a hot topic here in the United States. In fact, there is yet another case before the Supreme Court that issue is addressed, at least tangentially. And so, John, would you like to discuss for us, please, the approach that has been taken on that particular point?
Sure, and for those following along in your rule books, this is old Article 19, which will be Article 21 in the new rules. And with apologies to all our friends in other countries, this is a very American problem to which we've attempted to craft a solution. There's no nutshell in which this fits. So let me go back to, in a case in 1995 called First Options of Chicago against Kaplan, the Supreme Court said that whether a question is arbitrable and therefore can go to arbitration or has to go to court is an issue primarily for a court to resolve, unless, the court said, the parties have clearly and unmistakably delegated the decision, the ability to make that decision, to the arbitrators. And of course, you would think, clearly and unmistakably would be clear and unmistakable concepts, but they have proved anything but. This has been something of a controversy over the 25 years since then. And one of the controversial questions has been, do parties, by selecting a set of arbitration rules, such as the ICDR rules, which have in them a jurisdiction provision which says that the arbitrators may rule on their own jurisdiction, thereby clearly and unmistakably delegate to arbitrators the ability to make decisions about questions of arbitrability? Faced with that question, almost all of the federal courts, and this generally is a federal question because of the Federal Arbitration Act, almost all of the courts, and the courts of appeal especially, who have looked at that, said yes. If you have selected a set of rules, and that would include UNCITRAL, ICC, the AAA commercial, the ICDR rules, which has such a provision in it, then you have clearly and unmistakably delegated to the arbitrators the ability to make this decision. And of course, that does not give the arbitrators the last word, because a court always has the last word on jurisdiction. But what it means is that you don't need a side trip to the court before the arbitration commences to get the decision made. You can go all the way to the award, and then at the either set aside or confirmation stage, the court can look and decide if the court is happy with the way the arbitrators resolve jurisdiction. So that insurance policy is always there. So this was working just fine until the restatement of international commercial and treaty arbitration, which is now in its final draft. It would have been issued this year, but for the pandemic, I don't know when it will actually get to press, but it's finished. It is a great work. I recommend it to all of you. It does a beautiful job of organizing in clarifying American law on international arbitration, but it screwed up on this point. George Berman was with us yesterday. I haven't seen his name on the screen today. But George, if you're here, take your camera off and you can weigh in now and push back. It was hotly debated among the advisors and the members consultative group and the reporters and the ALI council whether the restatement should follow the majority rule in the courts or should disagree with it. And the restatement ended up disagreeing with the courts and saying the mere incorporation of a set of rules is not enough to clearly and unmistakably delegate the power to arbitrators, because the reporters reason that I'm simplifying here, such an election does not clearly exclude the courts. I have argued, but have been unsuccessful at arguing, that it would be pointless to exclude the courts because it is fundamental American law that you cannot confer jurisdiction or withhold jurisdiction on a court by agreement, so that it is completely irrelevant whether a party says the courts may or may not get to this. I was not persuasive on that point. So the restatement in any case says the mere election of rules is not enough because it doesn't exclude the courts. So the change to Article 20, what was 19, what becomes Article 21 is to put in two phrases. One is to flag arbitrability as something that arbitrators may decide as a matter of jurisdiction. And two is to say that they may go ahead and make these decisions without any need to refer such matters first to a court. And that does not either confer or deny jurisdiction. It just tells the arbitrators you don't need to wait, you can go ahead. And the entire purpose of those two changes was to give comfort to a reviewing judge who might be concerned about the position taken in the restatement, and be comforted that, you know, these rules now do what the restatement says needs to be done to the extent it legally can be done. And the court should accept the incorporation of these rules as being a first options election to leave these matters in the first instance to the arbitrators. So that I apologize for the length of the explanation. That's what we've tried to achieve. Most of the discussion yesterday was fairly positive about this, with some suggestion that perhaps the change didn't go far enough. And in my view, the change goes as far as the law permits us to go. Beyond that, I think if we simply said courts are excluded, it would be meaningless language because it would have no effect.
Thank you. For those of you who are particularly interested in this issue, next week before the US Supreme Court will be the argument in the Shine case, which has in it this particular issue of delegation. And I might add that George Berman filed an amicus in that case, and that petition, which was a cross petition for writ of certiorari, was actually denied. So the issue is still extremely interesting for everyone to follow. And we think that this is a great addition, and it was an idea of John's, and he's to be applauded for coming up with it. The next word, and I noticed that some people are having a little trouble with my Texas accent, so I will repeat it a couple of times. The next word for the CLE is rules, and that's plural, R-U-L-E-S, rules. The next issue that gendered some comment yesterday related to arbitrator challenges, and in particular, a new provision that we've included that permits parties to a challenge an arbitrator for failure to perform his or her duties. And John, would you like to address that one as well, please?
Sure. This one is a little trickier. What the committee did was to add to the rule on arbitrator challenges a specific provision putting inability of the arbitrator to perform the functions of an arbitrator as a grounds for challenge. And some of the discussion yesterday expressed discomfort about that. with expressing the concern that the rule could be misused, that it could be used tactically to delay an arbitration and to muck things up. And you know, it could. But the committee felt it was more important to have an explicit provision in there permitting a challenge. And this usually comes up if an arbitrator has just become ill or overloaded or just isn't doing the job for some reason. And it simply permits a party to bring this to the attention of the ICDR. And at that point, the ICDR's challenge procedure clicks into to operation. My guess is that, you know, a question like this would go to the Administrative Review Council because it would be a fairly grave question whether an arbitrator had ceased to function. But the judgment made was that, you know, this does happen, luckily not often. In the interest of transparency, the rule should acknowledge that it can arise and provide for what happens if it does. And so that's the only change, is to flag that as a possible ground for disqualification. I think probably without that change, a party could still raise it and the process would still work. But there's sort of a policy question of whether these rules should be accessible to people who don't do this work all the time, as most of the people on this call do, but should be able to just look in the rules and see what should happen in what order. And for that reason, we felt that, you know, it should be explicitly spelled out.
Thank you. In 2006, we adopted the emergency arbitrator provisions, which have been extremely successful, but with these rules, we are suggesting some additional language to be included. And Lucía, would you like to address that?
Yes, of course. The emergency measures protection, of course, has been very useful. And the main change that it's introduced is the requirement of showing the injury of prejudice that the party will suffer if the relief is not provided. I think that this was a very important feature in order to avoid notorious frivolous requests. But of course, this is something that was raised yesterday in the discussion, that some of the practitioners were concerned if this will be some difficulty to showing the injury of prejudice. But of course, this is something that we believe that it's important, and it's in line of, for example, the UNCITRAL model rules that establish that same requirement. No, there are another issues that were introduced, that, for example, specifying that the emergency rule, the emergency measure is requested before the tribunal is appointed, no, and of course also is making clarifications on the time limit of the 1 business days in order to appoint make the appointment of the arbitrator. And but of course, this is something that we already have in the rules, that it's a very short time to appoint the arbitrator. And of course, there were some discussions about the difficulty to comply with this 1 day period, but of course, this is something that we have already in the rules.
Okay, thank you. Yes, I found that interesting that there was a comment about the short time period, and I do think that the ICDR rules have the shortest time period of any of the institution rules regarding the appointment of an emergency arbitrator, but they seem to make it work. And so kudos to them to be able to do it in such a short period of time. One of the rules that we have had for some time also has been joinder, but there has been some tweaking of that as well. And John, would you like to discuss that particular point?
Sure. This you know, joinder comes up when an arbitration has been commenced, you know, by parties A and B, and one of them wants to add party C, or party C wants to get in on it. And the rule as it exists, and it's the current rule is 7.1 and the new rule would be 8.1. The current rule would require consent of everyone to join a new party after the tribunal is constituted. Before the tribunal is constituted, it's not a major issue. The ICDR can deal with it administratively. There are provisions in the rules. If everyone doesn't agree on the choice of arbitrators, the ICDR can appoint them, and then it's fair to everybody. So if the joinder issue comes up before constitution of the tribunal, it's an administrative matter and is dealt with by the ICDR. Once the tribunal is constituted, the addition of a new party implicates several kinds of consent. You know, what one is, has the new party consented to be joined to the arbitration? Second, have the existing parties consented to the joinder of the new party? And has the new party consented to the constitution, to the tribunal as it has been constituted? The latter has been identified by a number of courts, most famously by the French Court of Cassation in the Dutco case 30 or 40 years ago, as an important right of a party that can't be just iced over by saying, well, you're too late, the tribunal already exists. The parties have a right to have a say about who their arbitrators are. So the tweak to the rule is to say that once the tribunal is constituted, if the question of adding a party is raised, that can be done if the new party consents. And the consent would, of course, be not only to be joined, but to the existing tribunal. So first, the new party must consent. But it does not require any longer the consent of both the existing parties. It allows the tribunal to make a decision, provided that the new party consents. The tribunal in existence has been constituted by the current parties, and it is given the power to say, we're going to bring this party in, notwithstanding that party B doesn't consent to that. So it really is conferring an additional power on a tribunal to add a party, provided that the added party consents without the consent of the original two parties. And that's, I think, the only change from the current rules.
Thank you, John. New Article 39, which is former Article 36, relates to the deposits and the responsibility of parties to pay the fees requested by the ICDR. And there have been a significant change to that particular rule. And Alan, if you would discuss that, please.
Happy to. Actually, there are two changes. The rule as it existed, now it's in Article 39, but as it existed, we set forth that a failure of a party asserting a claim or counterclaim, their failure to pay the required fees or deposits could be deemed a withdrawal of the claim or counterclaim. But a clarification was added in the new rules, or will be added, that says in no event, however, shall a party be precluded from defending against a claim or counterclaim that's been made. And second change that's made in 39 now is that if deposits aren't paid promptly and in full, then the administrators has a duty already to inform the parties in order that one or more of them may make the required payment. So if one party doesn't make it because they've decided they don't want to for whatever reasons, and I think all arbitrators have been sitting long enough, have seen this case. I saw it first over 30 years ago. It now states that if such payment is made by one of the more of the parties, the tribunal may, upon request, make a separate award in favor of the paying party or parties for recovery of the payment together with any interest. Apparently that has become an issue of contention, so it makes it clear here if one party does choose to pay all the fees and deposits so that the proceeding can go on, then they can have a separate right, clearly stated, that they can recover that as in an award if the tribunal so deems it appropriate.
And I think the concept behind this actually is that when the parties agree to arbitrate, they agree to pay the fees. And so the failure to pay the fees is a breach of that particular portion of the arbitration agreement. And that's what would empower the arbitrators to, in fact, award fees for this, in essence, breach of the contract.
Now, this really helps reinforce that philosophy, I think, and make it clear that's the foundation of the philosophy.
Right. So we had a few other changes in the rules that I will address very briefly because we are almost out of time. We have the consolidation rule, which is formerly Article 8 and will now be Article 9. And in the past, it required that it be the same parties for purposes of consolidating two arbitrations. And that has now been changed to related parties in an attempt to bring in other related parties, subsidiaries and the like to make consolidation a little more flexible than it is right now. The reports that I've gotten about the use of the consolidation arbitrator, which of course is unique to the ICDR, have been extremely positive. And it seems to be a provision that works quite well. We also are now imposing another obligation on arbitrators besides the basic obligations of being impartial and independent and the requirements that the ICDR already has in place. And that is that they also have to act in accordance with the Code of Ethics for arbitrators in commercial disputes, so that we have even greater transparency as it relates to the arbitrators and also greater ethical standards and requirements for the arbitrators over and above what many of the institutions have. Another change that has been made relates to the publication of awards. It has been within the ICDR's discretion for some time under some instances to publish awards. There has been this greater call for transparency in arbitration, and in an attempt to meet that call for greater transparency, the ICDR new rule will allow for the publications of awards redacted on certain key points, provided a party does not object. So the parties will be receiving information stating that their award is going to be published unless they file an objection. This is in accord with a number of other institutions and is also furthers this concept of transparency that has become such an important issue in international arbitration. With that, we have covered pretty much the waterfront of what we are attempting to do with these rules. The comments that were made yesterday, which we will take back and consider with the rules as we have them now drafted, have been extremely helpful and helping us to note where there may be, for instance, some ambiguities or some additional wordsmithing that needs to be done, or in some instances requiring us to go back and look at the rules a little with a little more scrutiny. And so for that, we thank you for your participation in this process. This process has not only involved our committee, but also the management of the ICDR and now you as well, and we thank you for that. We are a few minutes left, no other than what are the code words. Steve or Eric, do you have any comments you'd like to make?
Actually, Anne, just one comment to thank you and Alan, Lucía, John, and our other members of the committee. You can see the command that this group has over these issues and the thought that's been gone into the changes that are being made. So really, our thanks to you.
Well, we were very pleased to be asked to work on this extremely important project. And I think as a result, we've all become much better arbitrators because of it. And so I thank you on behalf of the committee. We have one last code word. And well, here's a question that we've gotten, and this one would be one for Steve or Eric to answer. It is, are there plans to make any changes to the AAA rules to align with any of the changes to the ICDR rules?
There's been some discussion on the domestic side, but that's really been prompted in some respects by the developments that have taken place within the United States. So I think in the next year, you will see some effort to discuss potential changes. But I don't want to necessarily say that the changes we've made or plan on making to the international rules will be wholesale adopted domestically. They really have been tailored to international arbitration. So the answer is we will be taking a look at the other sets of rules to determine what provisions might be appropriate. It's not going to happen immediately.
Thank you. And for the last word, the fourth word, and hopefully my Texas accent will not get in the way, revision. That's singular, revision. Thank you very much. Steve, Eric, would one of you like to take over?
Sure. Thank you very, very much. That was a great discussion, and also hearing from the feedback of yesterday's Tertulia. So thank you. We have just a couple minutes transition as we move from this panel to the next. And so give us a few minutes to activate the next group. And again, thank our faculty for this session. And Luis Martinez will be sharing the next session and giving that first CLE code word and moving on from there. So give us a few minutes. Again, we remind people that are not faculty, if you could turn off your cameras so we can have those that are speaking be at the forefront of the screen.
I'd like to thank you all for attending the final session of our Americas program, the rapid fire session, where we've joined panelists from various countries from the Americas that are going to provide us with some important regional updates impacting international arbitration today. This session was always featured in the ICDR's annual conferences that we used to do when we had events in person, and how I miss those days. I never thought they would disappear so dramatically as they all have done. But I really hope that we can all get back together soon and do these programs in person, where we can see and interact with all of you personally. So I do want to say a few housekeeping items, but I did want to say thanks to my colleagues Steve Anderson and Rafael Carmona for all their hard work in putting this program together. Really appreciate it, gentlemen. So in terms of housekeeping, we will be sending the speaker CVs and materials related to all the sessions after the program. If you have actually questions throughout this particular session, please post them in the chat mode, and as time allows, we'll address the questions from the audience, although it will be challenging because we have a number of speakers and limited time. Now, I do have to say the CLE verbiage that throughout today's webinar, we will provide code words which are required for verifying attendance for CLE purposes. If you'd like to receive the CLE for attending today's webinar, please make sure you keep track of these words that I will provide throughout the session. There'll be a total of 5 words that will be interspersed throughout the session, and I can't give them to you after the program. Approximately a week after, our AAA Education Services will send you an email letting you know what are the instructions to receive your CLE certificate. Now, I will kindly ask the audience to please keep their microphones and cameras off. I'll invite all the speakers for our session to turn on their microphones and cameras. And let me start off with the first code word for today's webinar. It is Americas. I'll repeat it, Americas. Okay, as time is of the essence, I do quickly want to mention our panelists. From Argentina, we have Mariana Loza from DLA Piper Argentina in Buenos Aires. From Brazil, we have Mauricio Gomes Santos from GST LLP in Miami. From Canada, we have J. Brian Casey, Independent Arbitrators, Bay Street Chambers, Toronto. From Chile, we have Elena Meriminskaya from Wegeman Lawyers and Engineers, Santiago, Chile. From Ecuador, we have Xavier Andrade from Andrade Veloz Abogados in Quito. From Mexico, we have Elsa Ortega from Ortega and Gomez Ruano, Mexico City. From Peru, we have Roger Rubio from Rubio Arbitration Law in Lima. And then from the United States, we have the Western United States represented by Gary Benton, Palo Alto, United States. And on the East, we have James Hosking from Chaffetz Lindsay in New York City. And I'm your moderator, Luis Martinez, Vice President of the ICDR. So let's start off, and our travel takes us to Argentina and Mariana Loza. Each speaker has about 8 minutes. Because of the time sensitive we have to watch, I'll give each speaker a 2-minute warning that their time is running out. So Mariana, the first question goes to you. The scope of domestic courts' powers in reviewing arbitral awards is on the front page of the newspapers. Can you share with us a recent decision rendered last year on the power of the domestic courts to review and amend an arbitral award so as to comply with Argentine public order? And we understand that there is a new law on international commercial arbitrations that is actually aimed at limiting the judicial court's powers. Tell us about the case, and has that law succeeded in that regard? Mariana, the floor is yours, and welcome.
Thank you very much, Luis. And I would like to thank the ICDR for this kind invitation. As you said, we'll be speaking about a kind of recent decision in terms of, it's a decision from last year, but it goes without saying that 2020 has been a very peculiar year especially for Argentina, who has had a very strict quarantine, which has, of course, affected all the judicial courts. So we have not had too much activity probably this year. That's because also electronic filing is not so well developed yet in Argentina, although we are getting there more and more. So the decision I would like to refer to is the decision in the Deutsche Rack v. Caja Nacional de Ahorro y Seguro case. It's a decision rendered by the Supreme Court of Justice of the Argentine Republic in September last year. And in that case, the Supreme Court was required to get into the scope of domestic courts' powers in reviewing arbitral awards, which has been very sensitive always probably in most countries, but in particular in Argentina. As we will see, it was a case in which the Supreme Court looked after the respect for Argentine principles of public order by kind of adapting the award instead of ordering its annulment. And the reason for doing that was that it sought to stay to the principle in favor of enforcement of our foreign awards, which is, of course, great news for the Argentine arbitral community. In that case, the Supreme Court of Justice responded to a request for the enforcement of an arbitral award issued and confirmed in New York. The award required the respondent, which was an Argentinian state-owned enterprise, to pay compensation plus interest accrued due to the alleged breach of a contractual relationship. So the question was whether a foreign award, and this was a foreign award, could be enforced in accordance with the Argentine debt consolidation regime that applied to this particular award and deals with the restructuring of the state's debt, which is considered a part of Argentine public order, or whether an award could only be enforced without any sort of modification. As I said, the Argentine court, the Supreme Court went for the first alternative. The Supreme Court considered that following the Argentine Procedural Code, the recognition and enforcement of a foreign award must comply with public order principles of Argentine law. In that respect, it acknowledged in this case that ordering the enforcement of the award originally rendered by the arbitrator tribunal implied a violation of public policy for basically two reasons. First, the award contravened exceptional norms associated with Argentine's national financial crisis. And second, execution of the award would have implied granting the claimant rights to collect against the state that would be superior to those deriving from a domestic judgment, thereby violating Argentine's constitutional principle of equality. In this last respect, the Supreme Court confirmed that the judge of the exequatur may not impose stricter conditions than those applicable to the recognition or enforcement of national arbitral awards contained in Article 3 of the New York Convention. The Supreme Court also relied on Article 7 of the New York Convention and further held that if there is a more favorable domestic law which permits the enforcement of an award, and the party seeking enforcement wishes to rely on that law, as was the case in this arbitration, a court located in the place of enforcement has no discretion to determine whether that more favorable provision should apply. So the Supreme Court went on to explain in detail that whenever a domestic judgment is rendered in violation of, in this case, debt consolidation regime, which is considered part of public Argentine law, that judgment is not subject to an annulment that, or not subject to enforcement, but to an amendment. So it can be complied with in accordance with the debt consolidation regime. In other words, like a national award, arbitral award, the execution of a foreign award, which was in this case the one rendered in the Deutsche Rugby Caja case, should be carried out in accordance with the provision of Argentine public order. If an award is not in accordance with that system, the debt consolidation system or regime, the solution is not to reject recognition or enforcement of that award, but to adjust that award or amend the award to the debt consolidation regime. Thus, the Supreme Court granted the claimant's request to seek partial enforcement of the award in conformity with Argentine law. That means the Argentine's debt consolidation regime. Of course, it noted that such ruling did not imply the modification of its substance, but rather the recognition of the plaintiff's right to invoke the rules of the place where the award was being enforced. In a separate decision rendered by one of the justices of the Supreme Court, Justice Rosenkranz, this issue was developed in depth. He highlighted the fact that Article 5 of the New York Convention, and not only the Argentine Civil Code of Procedure, provided that Argentine judges cannot enforce an award if it contradicts rules of public policy of the state in which enforcement is sought. In an obiter, Justice Rosenkranz also pointed out that the New York Convention in no way allows the court to consider a request of enforcement of an award to review the merits of the decision adopted by an arbitral award. And in that sense, Justice Rosenkranz highlighted that the reviewing powers of a court who is deciding a request for enforcement is limited to either recognize or not an award, but could never mean an authorization to modify an award by getting into the merits. And this is, of course, of extreme importance, okay, considering that some previous decisions rendered by Argentine courts follow the other way. So that's why this decision is so central. In connection with the second part of your question, Luis, let me say that the new and first Argentine law on international commercial arbitration, enacted in 2018, seeks to solve these sort of problems that Argentine courts often face when dealing with enforcement proceedings. The new law basically follows the model law and contains the principles of the New York Convention. And we can find two provisions that refer to this public order phrase. One is in connection with annulment proceedings. The law refers to Argentine public order as one of the grounds for vacating an award. Whenever an award is contrary to Argentine public order, the award shall be annulled. But the other provision is in connection with the enforcement proceedings. And here the law rephrases the New York Convention and states that recognition and enforcement of award, a foreign award, can only be denied whenever the award is contrary to international Argentine public order, not just Argentine public order, which is a way of restricting the power of the courts when reviewing an award in an enforcement proceeding. So what we see is this attempt to limit the scope of provision of arbitral awards by Argentine courts, which is always welcome considering the history of wide powers Argentine courts have showed before arbitrations. Thank you very much, Luis.
Thank you very much. Nicely done. Before we turn to Mauricio Gom in Brazil, I'd like to give the second code word today. The second code word is rapid, R-A-P-I-D, rapid. Okay, Mauricio, we turn to you now, continuing with our rapid fire program. Can you discuss a recent decision by the Sao Paulo Court of Appeals that vacated an award and how it actually impacted the arbitrator's duty of disclosure? Mauricio, the floor is yours.
Okay, Luis, good afternoon. Thank you very much for this kind invitation. Thank you also for the entire ICDR team for putting together this amazing program. It's so nice to see familiar faces and familiar names. I'm going to split this question into two, if I may, within this allocated time. First one, I'm going to just give you all a sort of overall idea of the development of arbitration in Brazil, and then I'm going to address the question, the specific question. Now, the quick background. Prior to 1996 in Brazil, country had no experience at all with arbitration. Had some experience with border conflicts, but it's not the subject of this case, this discussion. So Brazil had an outdated arbitration legal regime. This is just 24 years ago. The reality was changed in 1996 with the passing of the Brazilian arbitration law and the ratification of the New York Convention in 2002. Important issues to consider was on the investment side for foreign investors or foreign parties. Brazil was granted investment grade by the major agencies. As a result, increasing number of foreign direct investment in the country, creation of Brazilian subsidiaries of foreign entities to do business locally. And also, Brazil was selected to host major sports events such as World Cup and the Olympics. If we put everything above into a blender, we can conclude that domestic cases, as well as those with foreign parties, skyrocketed in Brazil during the last 2 decades. Also, and I can assure you all that Brazilian arbitrators have increasingly been appointed in the international arena. Fast forward a little bit, 2015, there was a need to amend the 1996 Arbitration Act in order to match the current case law. 2 topics are worth mentioning. One is the express permission for the so-called public administration, meaning state and state-owned entities, to participate in arbitration. Brazilian case law had said this already, but it was a need to put this into a law, in a sort of a civil law tradition. And the other issue was a whole new chapter regarding provisional measures was introduced, and which essentially says the following: if an arbitral tribunal has been constituted, it is for the arbitral tribunal to review and rule on that provisional measure request. If the arbitral tribunal has not been constituted, it's for the courts. Now, going to your question. So with that, vol d'oiseau, now I go to the question that you've just asked. The duty, which goes to the topic of the arbitrator's duty to disclose. First and foremost, the basics. The Brazilian Arbitration Act follows the ancestral model law, the duty to disclose any circumstances likely to give rise to any justifiable doubts as to impartiality or independence. Local arbitration or institutional rules have also the same approach. So the basics are there. Here is what happened in one particular case, recent case, which was ruled by the São Paulo Court of Appeal. Picture this. First arbitration between A and B. Arbitrator Z is selected as the chairman by the party-appointed arbitrators. But there is a second arbitration between B and C, where the subject matter of the second arbitration was alleged to be similar to the one discussed in the first arbitration. B, in the second arbitration, appoints arbitrator Z as party-appointed arbitrator. Z does not disclose to A in the first arbitration that he had been appointed as co-arbitrator in the second arbitration. Proceeding goes along, and the arbitral tribunal renders its award in the first arbitration. A, in the first arbitration, is not pleased with the result, nor with some procedural rulings issued during the course of the proceedings, the first arbitration. A filed a motion for clarification once the award was rendered. Among other requests, the whole panel was asked to confirm the declaration of independence and impartiality. At this moment, after the award was rendered, the chairman disclosed that he had been appointed by B in the second arbitration. A then filed vacatur proceedings, which was initially denied by, by the court, and recently was reversed by the São Paulo Court of Appeals on the grounds that arbitrator Z had violated his duty to disclose. The São Paulo Court of Appeal for Americans, it is something similar to the Second Circuit. So the Court of Appeals held that the arbitrator Z, or the arbitrator in general, must be absolutely transparent and has to disclose all circumstances likely to give rise to justifiable doubts as to his or her impartiality and independence, not only before the role of arbitrator, but also during the entire course of the proceeding.
2 minutes, please.
Sure. The court vacated the arbitral award and all acts and rulings rendered in the arbitration and determined the matter to be subject to new arbitration composed by new panel. Interesting to note, in this case, there was the court mentioned the Abengoa case, which was an arbitration case, which some of you, or most of you already know, was an arbitration case seated in New York. The award in Abengoa case in New York was subject to vacatur proceedings and confirmation proceedings in light of the allegation of existence of attorney-client relationship between the law firm where the chair is a partner and the economic group that one of the parties belong. In Abengoa, the New York court's primary jurisdiction rejected vacatur proceedings and eventually confirmed the award. However, the award failed to be recognized in Brazil, the enforcing country, on public policy grounds due to the chair's lack of disclosure that his law firm had been engaged to deliver services for a company that belongs to the same group of one of the parties. Now, you asked me about the impact of this case the São Paulo Court of Appeals may have or will have in Brazilian arbitration, the development of Brazilian arbitration. I would say more court scrutiny on the facts to be disclosed in arbitration. The IBA colorful list has been used as guidelines, and I can imagine that's going to be increasingly used. Role of the institutions, the institutions may also step a little bit further in order to help the arbitrator to disclose other facts that, according to arbitrators, should not be disclosed. And those arbitral institutions, they set up already special committees in order to rule on challenges of the arbitrator.
Thank you,
That's
Mauricio.
my 2-cent comment, Liz. Thank you.
Appreciate it. Disclose, disclose, disclose.
There we go.
Okay, we now turn our direction north to Canada and Brian Casey. Welcome, Brian. Brian, the question for you is, can you tell us about a recent Supreme Court of Canada case where the court actually had the opportunity to look at the application of the New York Convention and the model law as it applies to arbitrations in the gig economy? Brian, the floor is yours and welcome.
Thanks, Luis, and for inviting me. And just before I start, as Mauricio said, it's nice to see so many familiar faces. Let's hope next year we can revert to doing this program in person and someplace that doesn't have a foot of snow outside. Just a little bit of background. Canada is a confederation of provinces, and so each province has exclusive jurisdiction with respect to arbitration. There's no overriding federal law, but it's not as bad as it sounds because all the provinces have adopted the model law, and all of the provinces have also implemented the New York Convention. And our Supreme Court of Canada is the final court for all of the provinces. So it's not inappropriate to talk about Canadian law because it ends up being the same just about in every province. So this case comes from Ontario. Mr. Heller. Mr. Heller brought a class action in the Ontario court on behalf of all Uber drivers in Ontario, alleging that he and his fellow drivers are employees and not independent contractors, and therefore are entitled to all of the employment standards benefits that the province has to offer. The agreement that Mr. Heller had entered into, the agreements are all governed by the law of the Netherlands, because it turns out that it's the Uber Dutch companies that actually own the licenses to the apps. And the agreements all provide for arbitration in Amsterdam under ICC rules. So we have an action started in the court, and Uber, what do? They move to have it stayed in favor of arbitration in the Netherlands. So first stop, the New York Convention. There's no question that the arbitration agreement is international. It was between Mr. Heller and the Dutch entities, even though the work was being performed in Canada. The question was, is the dispute commercial? Article 1 of the New York Convention says any country, any state can apply the convention only to differences which are considered commercial under the national law of that state. And in Canada, employee disputes aren't commercial. They're employee and labor disputes. And under the convention, it's the nature of the dispute that's determinative, not the relationship between the parties. So one could say, well, this is a commercial enterprise. Who cares? The allegation is, I'm an employee. Uber says, no, you're not. So the dispute is an employee dispute. And that takes you out of the New York Convention. Next up, the model law. The law applies to international commercial arbitration. There's no definition of commercial in the model law, but there's a whole bunch of categories it lists. But if you go to the commentary, which you're entitled to do, the commentary on the draft text of the model law says, labor or employment disputes are not covered by the term commercial, despite their relations to business. So you don't have a commercial dispute, you don't have the model law. That takes the court to the domestic arbitration law of Canada, in this case, Ontario. And in Canada, most of our domestic arbitrations are also primarily based on the model law. The Ontario Act says an action in a court will be stayed in the face of an arbitration agreement unless the arbitration agreement is invalid. Here, the Supreme Court of Canada said, well, this arbitration agreement is invalid. It's unconscionable. Here in this jurisdiction, that's an inequality of bargaining power that results in an improvident bargain. And a bargain is improvident if it unduly advantages the stronger party or unduly disadvantages the more vulnerable. It's a broader test than you'll find in the civil law and in other countries, but there it is. Here, the arbitration is in Amsterdam under ICC rules with all of the attendant costs and fees. And it turned out Mr. Heller, as an Uber driver, was making about $35,000 a year. So unconscionability was looked at the time the contract is formed, not at the time the claim is brought, because the claim that Mr. Heller has brought is a $400 million claim for all drivers. That's not unconscionable. You look at the contract and when it was formed, and at the time it was formed, you got this poor driver who clicks on a button and he's off to Amsterdam if he has a fight. So it's unconscionable, and the court action continues. Now, Canada is also a very strong competence jurisdiction. But here the court said, no, there's an exemption. A court should not refer a bona fide challenge on an arbitrator's jurisdiction under competence where there is a real prospect that the challenge would never be heard. So there's no way this would ever start, he'd ever start an arbitration. So they say there's an exception to competence. So in the gig economy, where you supposedly have independent contractors. At least in Canada, we've got 3 takeaways. The New York Convention and the model law don't apply if on the face of it, the disputes raise employee issues. The courts will look to unconscionability, the equitable doctrine, and competence is not going to save you. So in this one, it's off to court. That's it.
Thank you very much. Really appreciate that, Brian. Okay, now we're actually going to turn 180 degrees and travel way down south to our friends in Santiago, Chile. Alina, this question is for you. Alina, since the enactment of the International Arbitration Law Act, Chile has been deemed an arbitral seat with a great deal of potential. How do you assess Chile's capacity as a seat for international arbitration these days? And welcome.
Thank you very much, Luis, and thank you for the invitation to this great event. In my view, Chile continues being an arbitral seat with a lot of potential, and I want to stress the word potential here. The necessary conditions seem to be in place, but we still don't see any significant increase in international arbitrations. Chile has enacted the UNCITRAL model law in 2004, that is 16 years ago. Most of the provisions of this international arbitration law have been tested before ordinary courts, and most of them were applied in line with the international practice. So it's good news. Santiago, being the capital of the country, is usually named as the seat of arbitration. Because of that, the Santiago Court of Appeals has to decide on challenges against arbitral awards. Until today, no international arbitral award has been set aside by the court, and the decisions that were rendered were well-reasoned and showed great deference toward international arbitration. However, there are not more than 10 cases that we are aware of. So once again, the volume of international arbitration seems to be low, which is surprising for the globalized Chilean economy. There is still a trend within the local legal community to try to domesticate international arbitrations and to select local arbitral procedures. I have seen cases with contracts drafted in English that opt for an arbitration in English, but submitted to local arbitral rules of CAM Santiago, for example. So be aware of this trend that is still very common. And what is more important, there is still a confusion when certain arbitral proceedings should be treated as domestic and when they are international. This is a downside of a dualistic system as a Chilean one. A couple of years ago, a foreign arbitrator was subjected to a record which is only available in domestic arbitrations. It is called a record of complaint in case the award contains severe faults or abuses. And it is actually a disciplinary measure against the arbitrator in person. It is not an intent to set aside the award. And in that particular case, the arbitrator had to follow domestic provisions and to file a submission to the court in order to exonerate herself, to show there was no fault or abuse. The Court of Appeals afterwards decided that the award was indeed international, and the records of complaint was declared inadmissible. It only brought some troubles to the arbitrator and some negative publicity for the country. But the bottom line is, after some initial hesitation, the Court of Appeal applied the International Arbitration Act correctly. Good news again. However, in September of this year, the Supreme Court decided that an international award was suitable for an appeal before the Court of Appeals. What happened in this case was that the parties, one of them being a foreign party, a Mexican party, have provided for appeal in their arbitral agreement as well as in the procedural rules. After the award was issued and one of the parties launched the appeal, the Court of Appeals once again declined its jurisdiction, correctly stating that it was an international arbitration and there was no room for appeal. However, the Supreme Court invoked the principle of the procedural good faith, and considering that all parties agreed on having an appeal, and during the entire procedure were relying on this possibility of having an appeal, the Supreme Court remanded the case back to the Court of Appeals. This is plainly incorrect. The international arbitration law does not allow for court intervention unless specifically provided for, Article 5 of the UNCITRAL model law. So there is no room for appeal. And in that case, Chilean law applied to the subject matter in dispute. But let's imagine it would be a foreign law. The Court of Appeals is not well suited to decide appeals under foreign law. Therefore, there is one practical recommendation for foreign parties I could advance. When agreeing on arbitration with the seat in Chile, make sure that your arbitration will be deemed international and don't draft this sort of Frankenstein arbitral clauses, mixing national and international arbitration features. And to end on a positive note, Chilean legal circles have adjusted very well to the virtual reality. The judicial system, as well as the local arbitrations, continued operating online quite smoothly. And now that the geographical location doesn't seem to play any role any longer, Chile's potential to become an active arbitral seat might even increase. Thank you, Luis.
Thank you very much, Alina. Appreciate that. Okay.
Luis, we've lost your microphone.
Sorry. Before we turn to Ecuador, let me give the next code word. That code word is expert. I'll repeat that, expert. Okay, turning to Ecuador and Xavier. Xavier, let me give you the next question. Can you share with us the process of interpretation of the Constitution by the Constitutional Court regarding the validity of entering into BITs and its impact in the past, present, and future as you see it? Xavier, the floor is yours and welcome.
Thank you very much, Luis. Good afternoon, everyone. Yes, the new Ecuadorian constitution approved in 2008 contains a provision that prohibits entering into international treaties under which contractual or commercial disputes are submitted to arbitration. This is a little bit cumbersome. This provision is the result, on the one hand, of the political ideology of the moment, and on the other hand, of a clear misunderstanding of arbitration, where investment arbitration has been confused with commercial arbitration. As we all know, investment disputes are typically governed by international law, while commercial disputes are typically governed by local law and contractual provisions. So it is very unlikely to see a BIT where contractual provisions, contractual and commercial disputes are mandatorily submitted to international arbitration. However, Said limitation was the basis the Constitutional Court considered to wrongly declare that BITs ratified by Ecuador were unconstitutional. And as a result, Ecuador terminated, denounced all BITs as well as the Exit Convention. But considering the problems Ecuador has faced by these decisions, particularly when trying to attract foreign investment, a couple of years ago, the Congress requested the Constitutional Court to interpret the true scope of this constitutional limitation. This case is ongoing and has generated strong anti-arbitration activism through the submissions of amicus curiae briefs, including some from renowned academics around the world. But it has also allowed institutions such as the Ecuadorian Institute of Arbitration to guide the court in such difficult interpretation. And then, in the coming months, it is expected that the Constitutional Court clarifies whether the provision, this constitutional limitation, really prevents entering into international treaties with arbitration clauses. And I should emphasize that the new members of the court are people with excellent credentials, have proven to be independent from other powers of the state. So we are very confident that the court will do the right thing. The court's decision will undoubtedly have a significant impact on the past, present, and future of arbitration in Ecuador. Regarding the past, if the Constitutional Court determines, as we expect, that the rule didn't prohibit signing BITs, departing from the criterion of the former members of the court, the basis for considering those treaties unconstitutional would just vanish. On the present, Ecuador has applied to join the Pacific Alliance Treaty. However, this alliance requires that investment disputes are resolved in international arbitration. I think this will put some pressure on the Constitutional Court to interpret the provision in a timely manner, as countries that are part of this alliance are already demanding predictability on arbitration. And finally, on the future, if the Constitutional Court correctly interprets said provision, it is difficult to anticipate what the government would do with that. Will it try to revive the denounced BITs? Or will it try to renegotiate or negotiate new ones? Or just leave the issue as it is? Next year, we will elect a new president. And I guess that, as we have seen in the past, this decision will depend on the ideology of the new government. And arbitration is one of those subjects that politicians love to talk about in Latin America. I don't know why. There are more important issues they should be concerned about, but that's the way it is. Therefore, I think that the political pendulum will define how open the country is to foreign investment and international arbitration in the coming years. But this time, the Constitutional Court's ruling will seriously limit any political adventure. Thank you, Luis.
Thank you, Xavier. Very interesting. Okay, we are now going to look to Mexico and Elsa Ortega. Welcome, Elsa. Elsa, the question for you is, in July 2020, the USMCA substituted the NAFTA agreement between Canada, Mexico, and the United States. Can you tell us what are some of the changes in this new treaty with respect to investor state protections and claims? And welcome, Elsa.
Thank you, Luis, and thank you to the ICDR for their invitation. I'm very honored to participate in this conference. Yes, as you were mentioning, precisely on July 1st, 2020, the USMCA Treaty, in English, or TEMEC in Spanish, entered into force, substituting the NAFTA agreement between Canada, the US, and Mexico. And with respect to investor-state arbitration, there are several changes that I think are relevant to take into consideration. The first change is that Canada withdrew from the investor-state dispute resolution mechanism under the USMCA. Nevertheless, Mexican investors investing in Canada or Canadian investors investing in Mexico can still have access to investor-state arbitration under the framework of the Trans-Pacific Partnership Agreement or the CTPPP agreement, but it's no longer in place between Canada and the US. The second change that I think it's relevant is that in the past, the NAFTA agreement included protections for investments in the three countries in broad terms. And these were protections that are common in these kinds of treaties, including most favored nation or national treatment, or direct and indirect expropriation, fair and equitable treatment, etc. Under the present USMCA treaty, these protections are more limited and they are divided in two groups. The first group of investment claims that can be brought are against investment related with covered government agreements in covered sectors. And this means that these are agreements that have been entered with a national authority, as I was mentioning, between Mexico or the US only, and in a covered sector. And these covered sectors are only 5. They are oil and gas, it's power generation services, telecommunication services, transportation services, and certain infrastructure, which is ownership and management of bridges, canals, railroads, and roads, I believe. So if the investment is related with one of these covered government agreements in a covered sector, investment claims can be brought against violations of all of the wide range of protections that were in place in NAFTA. So it's the same protections that continue to be covering these kinds of investments under the USMCA. And this includes fair and equitable treatment, minimum standard of treatment, and indirect expropriation that, as we know, are the most commonly invoked in these kinds of cases. Now, the second group of investments is all of those investments that are not related with a covered government agreement in a covered sector. And these have a more limited protection. They only allow for investment claims for violations of national treatment, most favored nation treatment, and direct expropriation. Another thing that it's interesting to mention is that for these kinds of investments, the second group, there is a requirement to exhaust local remedies for a period of 30 months as a precondition for initiating one of these investment claims under the USMCA. Then also, with respect to claims for indirect expropriation, there is a provision now stating that non-discriminatory regulatory measures taken by states are designed and applied to protect legitimate public welfare objectives, such as health, safety, and the environment, will not be considered indirect expropriation, except in rare circumstances. So for these cases, we anticipate that this will be a provision that will often be invoked as a defense by states in cases of indirect expropriation. And then finally, I would mention that there's a transition period of 3 years as of July 1st, 2020, in order to be able to bring claims under the NAFTA with a wide range of protections for all investments. And the two conditions here are that the investment was established or acquired during the time that NAFTA was in force. This is between January 1st, 1994 and July 1st, 2020. And then the second condition is that the investment was still in place on July 1st, 2020. And I think that this is relevant, particularly with the situation that Mexico is living right now in respect to renewable energies. As I'm sure you are all aware, there have been certain measures by the Mexican government that are considered protective of the CFE, which is the private company with state-owned capital in the electricity sector. And this has been causing concern. And as I was mentioning, power generation services is one of those sectors that is covered and still has access to this wide range of protections under the new USMCA. Thank you, Luis.
Thank you very much. Okay, turning now to Lima, Peru, and Roger Rubio. Roger, the question for you is, can you share with our audience some of the highlights of the new amendments to the Peruvian arbitration law? And welcome, by the way. You're muted, Roger.
Thank you, Luis, and thanks for your kind invitation. It's a pleasure to share this panel with friends and colleagues. Okay, about amendments of Peruvian arbitration law. The Peruvian arbitration law, which is based on UNCITRAL model law, was enacted in 2008 and has been an efficient legal framework to develop the use of arbitration in private and public contracts in Peru. At the beginning of the year, the Peruvian government approved the Urgency Decree number 20-2020, which modifies some articles of the Peruvian arbitration law, in particular, the participation of the states in arbitration. The Peruvian state is a main arbitration user for infrastructure, construction, and concession projects. However, recently, the problems of corruption on these public contracts have negatively affected the legitimacy of the arbitration framework. The government has thus decided to define the arbitral regulation as a result to gain more control in state arbitration, to enhance the transparency and to prevent corruption or any situations which may affect the interests of the states according to the motivation of the amendments. There are in that 5 specific amendments that I'm going to mention. First, any arbitration dispute where the state is a party shall be institutional and decided by the law. Second, when a state party is affected with an interim measure, the private party must constitute a bank guarantee in favor of the state. Third, the challenge of the arbitrator must be decided by an institution, so co-arbitrator are prohibited from resolving the challenge. Four, the proceeding and the award are public when the arbitration is concluded. Fifth, when an award is annulled by the court, any party may challenge or replace the appointed arbitrator. Even though these amendments apply to state arbitration, they will have a direct impact in institutional rules and commercial arbitration. Congress is currently reviewing the law. There is a parliamentary commission that has provided a first opinion of the Constitutional Commission recommending to approve the amendments. Meanwhile, the law is in force and some public entities have begun to involve its application. Thank you, Luis.
Thank you very much, Roger. Appreciate that. Okay, let me give you the next code word, everyone. The next code word is legal. I'll repeat that, legal. Okay, we are now going to circle back to the United States, starting off on the Western United States and Gary Benton. Gary, can you share with us a recent GE Energy decision affirming the potential to compel arbitration against non-signatories? And welcome to the program.
Thank you very much, Luis, and I would be glad to do so. Let me begin by taking a step back and just sharing a view from the US that I know that James shares with me. And to do so, I really just want to echo some of the comments that Eric Tuchmann made yesterday and Ann Robertson made today. As Eric said, the US has been enduring the pandemic, and in fact, the process of international arbitration has in many ways benefited from it. And we truly have seen a smooth transition to online hearings, the expectation for hybrid hearings going forward. We had a successful New York Arbitration Week that was globally attended just this past week. And we see continuing growth from regional centers across the country. We've gotten through our election, and we expect our new administration to be much more focused on multilateral activities. And in terms of our Supreme Court, which is the focus of your question, The Supreme Court has largely been quite faithful to international arbitration. The case we're going to speak about, GE Energy Power Conversion France SAS versus Outokumpu Stainless Steel. Try saying Outokumpu 3 times fast. Everybody go ahead. That case has really confirmed that the US is in harmony with other New York Convention countries in many ways. In that case, which was decided June 1 of 2020, Justice Thomas, in a unanimous decision, issued a decision ordering that US domestic contract extension doctrines may be applied to allow non-signatories to arbitrate under the New York Convention. So let's pause and think about what that means. Of course, every country has its own domestic contract laws with respect to application of contracts to non-signatories. In the US, we're referring, of course, to common law doctrines such as equitable estoppel, which was the issue in the GE case, as well as other common law doctrines, agency, assumption, third-party beneficiary, and alter ego, to essentially extend arbitration agreements to non-parties. So the GE case involved 3 contracts for the construction of cold rolling mills at a steel manufacturing plant. And of course, you all know cold rolling differs from hot rolling because cold rolling of steel involves low temperatures for the rolling of steel. That doesn't really matter for purposes of our discussion, but you should know when you're discussing this case. What's important in the case, though, is that the contract, there were actually 3, they contained an arbitration clause. GE Energy was a subcontractor for the installation of motors to power the mills. And the successor owner of the plant, Outokumpu, sued GE in a US state court. GE removed the case to the US federal court and asked the federal court to dismiss and compel arbitration under the New York Convention. And the basis for doing so was that GE was applying, as I said, the doctrine of equitable estoppel. The lower appellate court, the 11th Circuit Court of Appeals, found that non-signatory extension doctrines are inconsistent with the convention's Article 2, Section 3 requirement that an arbitration agreement be made in writing. In looking at this decision, the US Supreme Court reversed and found that the New York Convention is quite obviously silent on the issue of non-signatory enforcement. And therefore, in a typical textual analysis that Justice Thomas is famous for, the court held that the convention cannot be read to displace domestic doctrines like equitable estoppel. So again, this case is confirming that US law is consistent with other convention jurisdictions in looking to domestic law to extend the basis for which an arbitration agreement would apply. The availability of non-extension theories are of course going to prove particularly important in cases involving subcontracting, distribution, and corporate group activities, all contexts in which we are looking to whether the non-signatory has either in fact or by law in some way consented to the arbitration agreement. Let me leave it at that, Louis.
Thank you very much, Gary. Appreciate that. Okay, we are moving to James Hosking in the Eastern United States with a question for James that actually Anne Rand Robin mentioned the case earlier. And James, can you share with us how the issue of the delegation of competence, Shine 2, playing out, which is to be actually argued on December 8, noting the promotion of Justice Barrett now on the bench, and the possible impact on the court regarding the Federal Arbitration Act. James, welcome and thank you.
Thank you very much, Luis, and thank you for the invitation. I'm pleased to say that post-election, as Gary said, we've been able to cross the geographic divide, and we're on the same page in saying that that international arbitrations continued to be actively engaged in the US during the pandemic. Not only other arbitrations, but as Gary alluded to, the Supreme Court has also continued to opine on issues that impact arbitration, both domestic and international. I am going to say something about the Henry Schein case, or Schein 2, as it's called, and the reason why it's important. First of all, as you said, Luis, it is being argued this coming Tuesday. So in terms of current developments, it doesn't get much more current than that. And the Schein case is basically the latest iteration in a long line of somewhat unique US case law on the question of whether it is for the courts or the arbitral tribunal to resolve questions of arbitrability. And in this context, arbitrability means whether a claim falls within the scope of the arbitration agreement. That line of authority goes back to at least 1995, when the court in a case called First Options and Kaplan said that gateway questions of arbitrability are presumptively for the courts to decide unless the parties have manifested an intent to delegate those issues to an arbitrator by clear and unmistakable evidence. And the courts have then spent the last 25 years coming up with a very robust interpretation of what constitutes clear and unmistakable evidence. One of those lines of cases is that where the parties have agreed to arbitrate in accordance with a set of institutional rules, and where those institutional rules contain a provision confirming the arbitrator's competence, or their ability to determine their own jurisdiction, that suffices as clear and unmistakable evidence, and therefore gateway issues go to the arbitrator. And so under the ICDR rules, if you have a provision like Article 19, then that constitutes clear and unmistakable evidence that the arbitrability issues go to the tribunal. Now, that position has been upheld by more or less every circuit appellate court in the United States. There are some gray areas, there are lots of nuances, but the basic proposition remains well accepted, but it is controversial, and I'm going to come back to that a little bit later. So what is the Schein case? Very, very briefly, Gary told you about the exciting world of cold rolled steel. This deals with the painful issue of dental distribution equipment, distribution of dental equipment. A suit was filed in Texas in 2012 in court. The defendant moved to stay the litigation and compel arbitration based on an arbitration agreement in a series of distribution agreements, which called for arbitration in Charlotte under the AAA commercial rule. So this is a domestic case, but the issues that I'm talking about are equally applicable in the world of international arbitration. The arbitration agreement in question had a broadly worded clause providing for arbitration of all disputes except for actions seeking injunctive relief and disputes related to trademarks, trade secrets, or other intellectual property. So it was a carve out of a particular type of dispute. And that's where the current dispute arises. Now, what happened? The trial court and then ultimately the Fifth Circuit refused to compel arbitration. To cut a long story short, they held that it failed the initial test as to whether the issue was to be rendered to the tribunal or not. That issue went to the Supreme Court. It came back down again to the Fifth Circuit, not addressing the issue of how to read the carve out, but merely what the right test was to apply. The Fifth Circuit then refused to compel arbitration again. And in this case, they held that the existence of the carve-out clause excluded any claims involving injunctive relief. Here in the original complaint, as it had been filed, while there was a $100 million damages claim, there was also a claim for injunctive relief. And on that basis, there was no clear and unmistakable evidence that the issue of arbitrability was to be decided by the tribunal. It was a question instead for the court. They rejected the Henry Schein's position that the scope of the carve-out, including the question about injunctive relief, is one of the questions of arbitrability delegated to the arbitrator by agreeing to the AAA arbitration rules. So it goes back to the Supreme Court. And as I said, it will be argued this coming Tuesday, December 8th. So it's a nuanced question of whether the carve-out exempts, whether a carve-out that exempts certain claims from arbitration negates an otherwise clear and unmistakable delegation of arbitrability to the arbitrator. So it's a very narrow, important but narrow issue. But I want to put it in a bigger context of two things everyone's paying attention to this for. First of all, at the same time that the unhappy Henry Schein petitioned the Supreme Court for cert to bring the appeal, the happy other side filed a cross motion to have the Supreme Court deal with this question I mentioned before of whether incorporation of the AAA rules or any institutional rules is clear and unmistakable evidence of an intent to delegate arbitrability to the arbitrators. The Supreme Court denied that petition. However, despite that, the respondents have briefed their case with that issue central to their argument, or as they put it, it is an antecedent issue resting at the irreducible core of the petitioner's case. And so they are asking the court to grapple with this very important question of what the effect is of agreeing to certain institutional rules. That's attracted some high-profile amicus briefs, including from George Berman, Professor George Berman, who gives the view of the restatement. And I see that there's already been some discussion on the chat on that. So I'll just very briefly, the key point there is that there's Professor Berman's view is that the type of competence provision that you see in the AAA rules or the ICDR rules is merely giving the tribunal authority to deal with those issues, but not exclusive authority. It doesn't preclude the parties from going to the courts on arbitrability issues. And there should be some clearer evidence of that preclusion if that's what the intended effect is. So it's up for a decision at the Supreme Court. That's the first issue people are looking at. The second issue, as Luis said, is we have a new Associate Justice, Judge Amy Coney Barrett from the Seventh Circuit. How will she deal with these issues? We don't know much from her prior record. There were 5 opinions that she authored while she was on the Seventh Circuit. Suggests a somewhat pro-arbitration view of the world, probably more so than the late Justice Ginsburg, but we really don't know. We shall see. So what's going to happen? Well, you can tune in because one of the upsides of the COVID pandemic is that you can actually listen to the oral argument next Tuesday and hear what happens. So watch this space.
James, thank you very much. Okay, we have a few minutes, and in true rapid fire tradition, I'm going to ask one question. You can agree, disagree, or just not sure. In the long run, will the pandemic have been seen as a positive to international arbitration in your respective countries? Mariana Loza, I turn to you first. Do you agree, disagree, or just not sure?
I must say I'm not sure because this whole pandemic has given us so much uncertainty on every aspect. But on arbitration, at least, for instance, in the Argentine case, what we see is, for instance, that this pandemic and all the issues now with the COVID-19 vaccine has raised the issue of arbitration as the probably more efficient way to solve disputes. It's for the first time that this year we see in contracts on the health sector clauses, dispute settlement clauses that contain arbitration, and that does not happen in Argentina in other type of contracts. So probably, and this was again in the front page of newspapers, arbitration in the COVID-19 vaccine. So it seems that somehow it contributes to show arbitration as a more efficient mechanism for solving disputes.
Thank you. Mauricio Gom, what say you? As the pandemic, will it help international arbitration in the long run?
I would, Luis, if I may, on the substantive issue and procedural issue. Substantive issue, I would say increase of cases based on breach of contracts, and most likely more arbitrations are coming from that specific issue. I would also say that mediation is on the rise, not only in Brazil, but also throughout the world, because it's not a matter of getting a good award, but also the ability to enforce and whether there is money from the other side. So I think that this is something that may happen. On the procedural side, I think the pandemic has brought this notion of virtual hearings. Everybody now is more comfortable with virtual hearings. Of course, there is challenge. There are challenges to everyone, challenges for the arbitrators, challenges for the mediators, challenges for the parties, and specifically challenges for counsel. It's a different world, different way of convincing the decision maker. But I think the pandemic, if it's apart from everything bad that the pandemic has brought to the entire world, in terms of solving dispute resolution, I think the pandemic has create a good development.
Thank you, Mauricio. Brian Casey, what say you?
Yeah, I think there, from my perspective, there's at least one benefit. It's certainly accelerated the change in the use of technology and the way in which documents are exchanged, arguments are exchanged. No more bankers' boxes full of paper. I haven't had one of those in 8 months now. It's great. I think, lawyers, let me tell you, you may have all heard this joke. How many lawyers does it take to change a light bulb? Change? This has forced lawyers to say, you know what? There perhaps are better, more efficient ways of doing things on technology. So if anything, that's from my perspective, something that's going to stay with us, that's been a benefit.
Thank you. Elena, what say you?
I say it will bring various benefits. First of all, the final clients should reconsider going to arbitration and will take to arbitration only the cases that really deserve being taken to arbitration, because the amount of controversies is so huge. So they will have to pick their battles. And I agree with previous speakers on technology. And I think we should be reviewing the standard procedural orders in order to include intermediate stages and to allow for issue to be disposed in a more efficient manner.
Thank you. Xavier, agree, disagree?
I agree. I think we have a positive future. Technology will lower or destroy some barriers to enter a broader market. Technology is neutral, is fairly inexpensive, which should allow more players to intervene in the market. So I think the decrease in cost of arbitration will attract more users and therefore have a bigger arbitral community.
Thank you. Elsa, what's your view?
Yes, I actually agree with what's been said. I think that it has been beneficial for the development of arbitration, and actually to the point where I think that this use of technology that Brian was mentioning, that lawyers normally would not like to try, but we have had no option but to do so, is not temporary. We have found a new, tools that will be used in the future once we have the opportunity to go back and meet in person. I think these virtual hearings and the way of we share information and arguments through technology will continue to be used in the future.
Thank you, Elsa. Roger, your view?
Thank you, Liz. Definitely, the pandemic has had a direct impact on the practice of arbitration in Peru. Before the pandemic, the proceedings were mainly conducted by physical documents and in-person physical hearings, but a few months after the pandemic started, the institutions, arbitral tribunals, and lawyers took several measures in order to continue with the course of the processes, such as measures related to protocols, guidelines, new or additional rules, digitalization of the documents, and virtual hearings. There was a positive reaction from our arbitral user, and the outcome has been successful. At present, arbitration in Peru works with electronic communication and notification with procedural calendars and virtual hearings through a digital platform. In other words, the arbitration is now more dynamic, and the communication between tribunals, parties, and the institution is more direct and fluid, and especially the pandemic in a short time has left behind traditional local litigation practice and consolidates modern international arbitration practices. Please.
Thank you, Roger. Gary, anything further?
It's a bittersweet question, isn't it, Louis? You know, the pandemic has been so horrific in so many ways, and yet for international arbitration, I agree, it has really been a step forward. We all would love to get back on planes and jet set off to Europe or Asia or Latin America, but that may not be happening anytime soon. What really matters is what the parties want. And I think corporate counsel have made it very clear that they do see the efficiencies from video conferencing and other technologies. And I think we will have it going forward as a positive.
Thank you, Gary. And James.
I'll just echo what's already been said, basically, and the real test will be what happens when we have the full panoply of options available to us. I do think there will be continued use of remote hearings, particularly for certain types of hearings. Electronic filing will be the norm, but we'll have the full panoply of options so that physical hearings can happen when appropriate. And I think that's going to be an important aspect of the future. But I guess one last thought is that I think also we've shown that through events like this, we've been able to keep up connections around the world without having to get on the plane or go to the cocktail party. As much as I missed both of those, I think it's shown that the bar has been very flexible in adapting to the new reality.
Well, thank you, James. Let me give the final code word for today's webinar. That word is developments. I'll repeat that, developments. And let me thank my panel. All of you were incredibly careful and sensitive to our time constraints, very informative, and I appreciate the time you spent in preparing for this rapid fire session. Again, I only wish we were together in some venue where we could follow up with a nice cocktail to close the event. This is the last session for the ICDR's Americas Conference. Again, on behalf of my colleagues, Steve Anderson, Rafael Carmona, Eric Tuchmann, and I, Luis Martinez, we thank you all very much for participating in this two-day event. And lastly, as I said, look forward to it again in person. Steve, I'll turn it over to you for the final words.
That's Luis, you said it all. Thank you very much. And we look forward to future time together, whatever circumstances that might be in. Thank you all.
Thank you all. Enjoy your day.
Thank you.
Bye-bye.